Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, all of you. Thank you very much for your attention today. Basically, today we would like to follow the guest lecture concerning Sharia economic dispute resolution and distinguished guest Dr. Sodiq Omoola from International Islamic University Malaysia, and also all of students from the master program, from Notary program, and also from Magister Ilmu Hukum program, and also from Magister Ilmu Hukum Jakarta class. Welcome to Faculty of Law Universitas Gadjah Mada. Today we have the meeting with Dr. Sodiq. I'm here despite moderator uh, based on the request from the notary program. I also will give a little bit presentation concerning the dispute resolution, especially in Sharia banking in Indonesia. So before the time we give to Dr. Sodiq Omoola, I would like to give a simple presentation because I think it's very important to try to compare between Indonesia and Malaysia concerning Sharia economic, not only in the implementation of the Sharia principle, but also how to solve the problem both in the court and also in the non-litigation forum. So I will give you a little presentation, please. Yes. So my PPT, the title of my presentation is the Sharia Economic Dispute Resolution in Indonesia. Mas Agus, can you give? Yeah, saying, yeah, okay. So my name is Khotibul Umam. Maybe some of you ever heard when you take the course, especially from Magister Ilmu Hukum Yogyakarta and also Magister Ilmu Hukum Jakarta. And for the notary program, I also will give you this course after Pak Muhaimin. So because I believe that I will give you a lot of information concerning the Sharia principle and how the implementation in Indonesia. So I just give you a little bit explanation. Basically, at least there are three outline. The first, we would like to talk about Sharia principle, and then how the implementation of the Sharia principle in the banking product. And the last, I will give you a little bit information concerning how the resolution of the Sharia economic dispute. Next. So, the first is how Sharia principle and its implementation in Indonesian Sharia banking. So, if you want to know about how the definition of the Sharia principle, you can find from the several law and regulation in Indonesia. So, if you try to find the law number 10, 1998, you can find the authentical definition. And in this slide, I just give you the definition from the newest law. I mean law concerning the development and the strengthening of the financial sector. Here, that the Sharia principle is the Islamic legal principle based on religious decrees and all statement of Sharia compliant issued by institution with authority in issuing such decrees. So it's mean that according to this definition, when we talk about the Sharia principle, we just look at in the positive meaning. I mean that you can find how the fatwa issued by MUI regulate several product and activities in the Sharia banking. And if we talk about how to fulfill the condition and requirement of the contract, you can look at the fatwa and also the regulation issued by in the previous year, maybe Bank Indonesia, and today the regulation from the Indonesian Financial Service Authority or OJK. So in this law and regulation, when we talk about the implementation of the Sharia governance from the Sharia Commercial Bank and Sharia Business Unit, you can find that the content of fatwa will be a substance of the regulation in OJK. According to law number 2, I mean Financial Service Authority number 2 to 2024, that despite fatwa in Indonesia also provide the specific committee, the name is the Sharia Banking Committee, to absorb the substance of the fatwa to be a regulation in OJK. And despite fulfilling the content of fatwa and also regulation from the authority, according to law concerning the Sharia banking, to fulfill the Islamic law, there are several values here: justice, beneficence, balance, and also universality. Yeah, so I said that fulfill the fatwa, fulfill the law and regulation, and also fulfill the values. It's mean that it is the positive meaning. It's mean that the banking industry must follow the contents of the law and regulation and also the fatwa. I also state in the next slide that despite fulfill the fatwa and also Sharia banking regulation, we must avoid several principles that belong to the prohibited principle or forbidden principle. There are several terminology here. The first, according to the Indonesian law, there are riba, maisir, gharar, haram, and zalim. In Indonesia, the main issue concerning the riba is that whether bank interest belong to riba, whether or not bank interest belong to riba. So according to the fatwa from Council of Ulama in Indonesia, especially in 2004, I mean, they state that the practice of the bank interest has fulfilled the condition of the riba nasia. Riba nasia means that it is kinds of riba will arise in the debt transaction or credit transaction. So any additional money in the credit transaction, according to the Council of Ulama in Indonesia, is belong to the usuries or riba. So the next issue is, if the bank interest is prohibited by the law, so how the solution, especially for the product and activities of the Sharia banking in Indonesia? Next slide. In Sharia banking in Indonesia, we know that the function is the same with the conventional bank. It's mean that both of them are the financial intermediary institution. So if we talk about the product and activities, the nature of the product is the same with the conventional, except in the basic transaction. So if the bank interest is prohibited by the law, so according to Islamic law, we know that several traditional contracts that are very useful if we use it for the product in the Sharia bank, in the final funding product, in the financing product or lending product, and also in the service product, by replace the prohibited element with the traditional contract based on maybe this sale and contract, I mean, the financing based on the lease contract, the financing based on profit sharing contract, or the loan contract. So the several product, you can find it from the regulation. Saving product also still exists. time deposit also still exists, and by replace the element of usury, the element of bank interest with the wadiah principle or maybe mudharabah principle. In the financing product, you can replace Sharia economic dispute. I think that in Malaysia also has the similar institution like in Indonesia. Yeah, in Indonesia, if the conflict happen among the parties, among the customer and also the institution, there are two type of the forum that will be used by the parties. Maybe the first one settle in the court, especially in the religious court. For the first time in Indonesian history, the religious court or peradilan agama has the authority to settle the problem in the area of the Sharia economic or economic Sharia. So in law number 3, 2006, Sharia economics belongs to the absolute competence from the religious court in Indonesia. The other legal basis you can find in the law number 21, 2008 concerning Sharia banking. In the article 55, you can find it that coherence with the previous law, that law concerning Sharia banking also known about the litigation process and also non-litigation process. If the litigation process, it belongs to the religious court competence, and if non-litigation process, it just based on the akad, based on the contract between the parties. So here, when we try to identify, according to the Indonesian law, that religious court and also arbitration court, I mean Badan Arbitrase Syariah Nasional, has the important role to settle the problem. But if we will use Basarnas as a forum to settle the problem concerning the Sharia economic, the first important thing that among the parties must make a arbitration clause in their contract. Yeah, and despite the law number 3, 2006 concerning religious court, and also law number 30, 1999 concerning arbitration law, in the religious court circular letter and also in the religious court regulation also regulate about mechanism about the procedure to settle the problem, especially if we find the issue of the arbitration award, for example, how the arbitration award will be effective. So it needs the instruction, I mean execution, fiat execution from the religious court. Yeah, not only Basarnas, not only religious court, but according to OJK regulation in 2020, yeah, also regulate concerning layanan alternatif penyelesaian sengketa. alternative dispute resolution services. Based on this POJK or OJK regulation, OJK strongly recommended that the conflict between the parties settle in the LAPS OJK. I think it is also very important because when we talk about the issue of dispute settlement concerning the cost, yeah, in this institution, if the customer and the bank bring the case into the LAPS OJK, so it is free process without any additional costs, yeah, to bring this cost into the LAPS OJK. And the last issue, I think that we also must remember concerning circular letter number 2, 2019, concerning the Sharia economic. You know that if the case between the parties is to annulment the contracts, it will be rejected by the court if the reason is that the contract is contradict with the Sharia principle. You can look at in the circular letter number 2 and 2019. If the annulment or cancellation happen, so as a consequences that the customer still have the obligation to pay the historical cost, ya, to pay the hutang pokok plus profit margin and also nisbah profit sharing. So you can look at more completely in circular letter number 2, 2019. So we'll back to the next slide, dispute resolution through Basarnas. So Basarnas itself has the two competence. The first competence concerning the file and swift resolution of muamalat, yeah, or a civil dispute, and then Basarnas also has the authority to give a legal binding opinion for the parties. Yeah, so for the detailed information, I think I will give you in the next meeting in the class. For the discussion, I have two questions to all of you. Next, the last slide. The first, how is the dispute over the annulment of Sharia economic contract resolved? It means that according to the Supreme Court circular letter, that cancellation of contract or annulment on contract strongly recommended that it's not happen. Why? Because the customer actually has got the facility from the bank. So if something happen, please don't cancel or don't annul the contract. And the second issue that does the existence of OJK, Lembaga Alternatif Penyelesaian Sengketa, LAPS OJK, eliminate the arbitration authority. Maybe in the theoretical level, it's not eliminate the authority of arbitration, but in practical, according to the practitioner, state that in the standard contract, if we still give the clause, the conflict clause, dispute settlement, still choose the Basarnas, so the OJK will suggest that don't use the Basarnas, but please use the LAPS taken from OJK. So several opinion from the Basarnas institution state that so it is minimized or eliminate the arbitration authority in the practical, but it's not in the theoretical level. So I think that just like this, my presentation concerning Sharia economic dispute resolution in Indonesia, concerning the Sharia principle, how the implementation of the Sharia principle in the contract, and also about the dispute resolution in Indonesia. So to make more comprehensive explanation concerning Sharia economic dispute resolution, especially in Malaysia. Today we have Dr. Sodiq Umala. He is assistant professor Ahmad Ibrahim Kuliyyah of Law, IIUM. He from the Doctor of Philosophy Ahmad Ibrahim Kuliyyah of Law, AIKOL, in 2018. Master Comparative of Law from AIKOL, also from IIUM. And also he has many expertise. He teaches the alternative dispute resolution and also company law and also equity and trust and also legal method. And he also has several publications. One of them is concerning framework for dispute resolution in Malaysia, higher education across jurisdictional analysis. So I think that according to your CV, I think you will explain to all of us here concerning how the dispute resolution, especially in Malaysia, focus on the area of Sharia economics. So the time is yours, Dr. Sodiq Umala, please.
Okay, thank you very much, Dr. Khairul. Am I correct with your name? Dr. Khairul, right?
Khotibul Umam. Yeah.
Oh, Khadilul. Okay. Yeah, sorry about that. I couldn't memorize the name. To the students, Assalamu alaikum. I hope you enjoy your studies. And this is one of the few opportunities that we can learn together. Just to share with you what we do here in Malaysia regarding dispute resolution in Sharia economy. So can I have the slides?
Okay, maybe will help from
Yeah,
the moderator.
already got the slide.
Okay, please.
Okay. So this topic is a huge one. It's Sharia economy comprise a lot of issues, a lot of industries. So, but at the end, we will have to zoom to one, which is Islamic finance. Okay, Islamic finance. Can we move on to the next? So this is the outline of my presentation. Before I go on, can I know how many minutes I have?
Okay, please.
Can I know how many minutes I will
Yeah,
have to present?
45 minutes maximum.
Oh, 45 minutes. Okay, that's a lot of time. Yeah, I think we'll be able to finish. Okay, so just kind of the outline, we'll be discussing about uh, a general introduction to Sharia economy and some principles and the scope of Sharia economy in Malaysia. And we will zoom down to the dispute resolution mechanisms within the Islamic economy. So I will be using the words interchangeably Sharia economy or Islamic economy. So they basically can be considered to be similar. Okay. So after that, we'll discuss about an overview of the legal framework on Islamic economy, basically focusing on the disputes. And the role of fatwa is very important. So we'll be talking about the role of the Sharia Advisory Council and jurisdiction of courts in Islamic finance. And one of the major issues, one of the main problems in resolving Islamic banking disputes is the Sharia non-compliance risk. So, which is a big problem for the banks in the past. So, we will talk about the problem in the past and how the problem is being resolved at the moment. Okay, and we'll conclude with some discussion on what we think is the way forward. So can I have the next slide? Okay, talking about Sharia economy is a big word. So when we mention economy, we're thinking about an economic system that is governed by Islamic principles. This is already mentioned by Dr. Khairul regarding some principles of Islamic economic system. Basically, it is derived from the Sharia. All the rules regarding the economy within a Sharia economy should be derived from the Sharia, from the religious code of Islam. Basically, the Quran, the Sunnah, the ijma of the scholars, and fatwa and few others. But one of the things we should know is that at the moment, we cannot simply say that our economy in Malaysia, in Indonesia, in Saudi Arabia, in the Muslim countries, we cannot say that it is absolutely Sharia economy. It is considered to be partial. So it is we can simply say it's about mixed economy. I hope you get the point. You can say it is mixed economy. Why mixed economy? Because we have Sharia Islamic banks exist together with conventional bank. Some banks have their windows, while some have full-fledged Islamic bank. So it is sort of a mixed economy. So this covers areas like banking, finance, trade, investment, and many business practices. So this is just a general introduction of what we should understand when we talk about Sharia economy. Next slide, please. So talking about the principles, these principles you already know. We will not be going into details of the principles of Islamic economy. It is basically about prohibition of riba, riba fadl, riba nasiya. These are issues we already know. So we will not be going into details of this. Prohibition of uncertainty, no unjust enrichment. You must work before you become rich. And talking about financing in Sharia economy, it is generally asset backed. It's based on asset generally. There are few products which are not necessarily asset backed. Yeah, those are quite controversial. Usually, you also have what is known as risk sharing. You share the risk between the investor and the person looking for finance. And another very important one is the prohibition of gharar. We prohibit harm whenever we are talking about Sharia economy. So that is why in the Sharia economy, we don't tolerate companies producing something that is harmful to the people, something that is harmful to maslaha. For example, arms and ammunitions, which can kill people, atomic bomb. We don't finance such a company. And lastly, a very important aspect of Sharia economy is wealth redistribution. What do we mean by wealth redistribution? This is elements of zakat and waqf. Zakat and waqf, where you take from the rich and give to the poor. Okay, through endowments, through zakats from those who are able to pay the zakat. So these are the general principles. We will not be going into this because the focus of the discussion is all about dispute resolution within the Sharia economy. Now you move on to the next. Okay, talking about the scope of Sharia economy or Islamic economy. In Malaysia, we can see that this chart, which is a kind of a best eye view, kind of a helicopter view of Islamic economy. If you are talking about Islamic economy, you will be talking about number one, Islamic finance. Islamic finance. In Malaysia, the Islamic finance sector is growing and it's one of the best in the world based on several statistics available. So we'll be focusing on that only, but there are other aspects of Islamic economy, which is also very important. Number one, after Islamic finance is halal food and cosmetic. Muslims are very interested. We should be interested in halal foods and cosmetic. For the ladies, you want to know the cosmetic products you are using, whether it is from halal sources. So that is why halal food and cosmetic is another industry which forms part of the Sharia economy. Others are Islamic social finance. It also includes Islamic education and research. So many universities which are based on Islam in Malaysia, also in Indonesia. So this is part of the Islamic economy. So we do lots of research on Islamic economy through the Islamic universities. For example, in IIUM, this is one of the things we do. Most of the research we have, they are focusing on what is the Islamic aspect of the research. Okay? So talking about Islamic finance, you have Islamic banking, you have takaful, or which is also known as Islamic insurance, and you also have the Islamic capital market. I don't know the level of Islamic capital market in Indonesia, but in Malaysia, we have the Bursa Malaysia, which is the stock market, where Islamic securities are traded. Islamic securities. So I don't know if the student already thought about securities law, where companies can seek capital by issuing shares to the public. So there is a separate window for Islamic finance companies or Sharia compliant companies to raise capital in the stock market here in Malaysia. So we will be talking about the dispute resolution aspect, but just to tell you about the scope. Next, please. Okay, now about the dispute resolution. We cannot go into more detail about the contract, how it's formed, but we assume that the contract already formed between the bank and the customer, or between the insurance company and the insurance purchaser, okay? If there is a dispute, what should be the method of resolving dispute? We can go to the foundation of Islamic law. What does the Sharia says about resolving dispute? What the Sharia says is that we should always pursue settlement. So in Islamic history, from the Quran and from the Sunnah, there are several methods of resolving disputes, which has been recognized by the Prophet ﷺ and by the companions. Few of them we mention here, but towards the end, we'll focus only on mostly two of it. Fatwa, which is the ruling, and qada. Qada, which is adjudication. But other methods include negotiation. For example, the bank and the customer can negotiate whenever there's a dispute. There can be mediation as well. If they cannot negotiate, they invite a third party. Third party can help them to negotiate. The basic difference between negotiation and mediation is the presence of a third party in mediation. Mediation is a third party facilitated negotiation. Can I say that again? Mediation is a kind of negotiation involving a third party who helps the parties to be able to settle. We also have other methods which includes conciliation, and very prominent, arbitration is also recognized under the Sharia. So the Arabic term for arbitration is tahkim. We'll get to understand some of the sources in the Sharia, in the Quran, which refer to arbitration. Other methods of resolving disputes, other mechanisms include qada, could also include Ibra. Ibra basically means you forgive your rights, you ignore your rights. Somebody owes the bank money. If the bank wants to forgive, as long as it's within their power to forgive, they can forgive the loan. It is allowed under the Sharia. Another point is regarding muhtasib. Muhtasib is basically referring to isba or ombudsman. This is one of the methods which is so popular and being practiced in Malaysia and few other places, but in different names. And lastly, we have the fatwa. But one important thing about dispute resolution in the Sharia is there is no limit. There is no limit to the options available as long as it leads to settlement. If the parties want to settle, they can use any method they wish that will lead to settlement. So any method that leads to settlement is known as sulh. Any method that leads to settlement of dispute is known as sulh. So as we go on, we will see which part of the method, which of the mechanism is applicable in Islamic economy or Sharia economy in Malaysia. Next, please. So let's look at some of the authorities. Some of the authorities for sulh generally, for reconciliation, for pardon, for tahkim. The first authority in the Quran regarding resolution of dispute is Surah An-Nisa. One of the verses is Surah An-Nisa, verse 114, where Allah subhanahu wa ta'ala says, La khayra fi kasirin min najwa ila ma amara bi sadaqatin aw ma'ruf aw salah bainan nas. So what this verse is saying that if you have a dispute, there is no point in giving secret talk, in talking behind the other party. There is no good in it, but it is encouraged to have charity. Give charity and be kind to the other. Whenever you have disagreement, be kind to the other party. And one of the good things that is encouraged in this verse is to encourage reconciliation between people. So this focuses on the parties should reconcile. It also encourages the party to reconcile between two people. Another verse, which is much more important, that covers Ibrah and covers pardon the other party, is Surah Ash-Shu'ara, verse 40. Surah Ash-Shu'ara, verse 40. So one of the most important words is regarding Islah. Okay, Faman khafa waslahu. That if you can pardon the other party and make reconciliation, your reward is with Allah. So it is not enough to just ignore the other party. You should try to reconcile. You get reward here in the world and also get reward in the hereafter. Next slide, please. And this next verse talks about arbitration, which is tahkim. Now in the Muslim world, in many areas of disputes, Islamic finance or family law, arbitration is very important. And there are very plenty examples of this in the Sunnah. Okay, so this verse of Surah An-Nisa, verse 35, talks about whenever there is dissension. This verse is talking about husband and wife. The context is husband and wife, but scholars have said that you can expand this prescription to other scope of endeavor, including family, including finance. Okay, so the key word here is wahakama min ahlihi in yurida islaha, meaning that you can call wahakama min ahlihi, wahakama min ahliha. You can call someone, an arbitrator, from the family of the wife and from the family of the husband. So the wife here represents one party and the other party, the husband. So this can be replaced with the lender and the borrower, the person who applies for finance in the Islamic bank. If they disagree, both parties in the transaction can apply for, can request for arbitration. When they request for arbitration, both arbitrators can decide on the dispute. However, there's something very important in this verse. If they both desire reconciliation, in yurida islaha, meaning that parties must agree first. The parties must agree to resolve the dispute. If they don't agree, there can be no resolution. So this is the principle of party autonomy, party choice. Party must agree to resolve the dispute through arbitration. Without that, there can be no resolution. Next, please. If you have a question, you can write the question in the chat so that we can answer later. So talking about the legal framework for Islamic economy, because we'll be referring to some of these laws in Malaysia, we'll focus more on Islamic banking, okay? The most important thing is the federal constitution. The federal constitution of Malaysia is the main legislation when it comes to all issues in Malaysia, including Islamic banking. After that, we can mention only regarding Islamic Banking Act, 1983. This law already repealed. These were the laws that enable Islamic banking to be properly legally registered in Malaysia. Okay, and for Takaful Act, this is for Islamic insurance in 1984. These two laws already repealed. Repeal means that already cancelled. This is no longer in force. The Islamic Banking Act and the Takaful Act. The next most important one is the Banking and Financial Institutions Act. We also have the Securities Commission Act. We also have the Capital Markets and Services Act and the Central Bank of Malaysia Act. I will mention some of these laws later. And the most recent and the most important to solve the problem that we have here in Malaysia is the Islamic Financial Services Act 2013. Okay, so for the halal industry, it appears that is not within the scope of our discussion today. Okay, so we move to the next one. But what is more important? What is more important is that there has been challenges. There has been many challenges in resolving dispute in Islamic banking or Islamic finance. But those challenges have been progressively addressed through legislation, through amendment, and through many court decisions. So the journey for Islamic banking in Malaysia is a continuous improvement of the law. Okay, so next slide. Okay, Dr. Zulkifli Hasan, one of the famous researchers regarding Islamic banking in Malaysia, divided the cases, the decision of courts in Malaysia regarding Islamic finance into different levels. At the first phase one, we have a situation where classical common law approach. Okay, for your information, just to share a background, Malaysia uses common law because of the influence of the United Kingdom, Britain, through colonization. So most of the laws in Malaysia is based on the common law system. So at the time, between 1986 and 2002, most of the court decision apply common law system or common law principle to Islamic banks. So this led to lots of problems because common law approach sometimes do not recognize Islamic law, do not recognize the fatwa, do not recognize the fact that Islamic law can be written law. It says that Islamic law is like customary law, which is not written. So because of this, become difficult. So this phase already passed because the law has been a little bit modified, okay? So now we move to the second phase. The second phase is phase 2 from 2003 until 2007. 2003 and until 2007. What happened in this era? During this time, you have many Islamic finance facilities. Many of them Musharaka, Mudaraba, BBA. I will mention about BBA later. This is one of the famous products of the Islamic banks, which is no longer considered to be Sharia compliant. So now many banks already stop using this product in financing for their customers because it's very controversial. So this phase, second phase, examine underlying principles of Islamic financing facility, which is the basic should be about Sharia compliance. So within this period, many cases, many Islamic banking products were decided by the court to be non-compliant with the Sharia. They were decided by the court and sometimes also by the Sharia Advisory Committee. They give fatwa that some of these products, they are not Sharia compliant. Okay. So the next phase, the phase 3, is constructive and interventionist approach. Constructive and interventionist approach. In this stage, many experts from the academia, from the universities, from the regulators, sometimes from the judiciary, they try to intervene to solve the problem because many Sharia products in the bank were considered to be Sharia non-compliant. They did not comply with the Sharia. So the banks were losing many cases. So we'll mention a few of the cases, inshallah. So this was what happened in 2008 and 2010. So there were interventions by scholars, by lecturers in the university. They do lots of research on how can we solve the problem of Islamic finance facilities not being able to scale through the Sharia non-compliance risk. Because if a product is not Sharia compliant, there will be lots of dispute. Okay? So now we move to the fourth phase, phase 4, 2011 to 2018. In this stage, you have lots of development regarding legal aspects. New legislations were made to strengthen the Islamic finance industry so that many cases that go to court will not be considered as a loss for the bank. So the judges will have a proper guideline on how to decide cases on Sharia dispute, okay? And finally, in 2019 until today, you have new framework which has been implemented. So we will see how these cases turn out. What do we have now and what do we have before here in Malaysia? Next, please. Okay, so now we talk about the role of fatwa. Two most important mechanism for resolving dispute is the fatwa and also litigation. Because many contracts amounting to millions of dollars, millions of ringgit, usually the parties will prefer to go to court. Okay, they prefer to go to court. However, when they go to court, it is important to know that the court will usually refer to the Sharia Advisory Council. The Sharia Advisory Council. The Sharia Advisory Council was established in 1997 based on the provision of the Central Bank of Malaysia Act 2009. Central Bank of Malaysia Act 2009 was repealed from the previous Central Bank of Malaysia Act 1958. So what are the improvements regarding the reference to Sharia Advisory Council? Sharia Advisory Council was established for the purpose of receiving referral. The courts will refer the cases to the Sharia Advisory Council for ruling, to give fatwa on Islamic products. So this new law in 2009, the law restates the establishment of SAC, meaning that the SAC was maintained from the 1958 Act, that now Sharia Advisory Council become legalized in the new act. Another very important thing is whenever you have two legislation or two decision, the ruling of the SAC prevail over Sharia Committee. What is the difference between SAC, Sharia Advisory Council, and Sharia Committee? Sharia Committee is the committee within the bank. Each bank or each takaful operator has their own Sharia committee. Okay, they have their own Sharia committee. Whatever they decide is inferior, is secondary to the decision of the Sharia Advisory Council. Sharia Advisory Council is not attached to any bank. It is attached to the central bank. Okay, Bank Negara Malaysia. It's attached to Bank Negara Malaysia. So the ruling, the fatwa given by SAC Bank Negara is superior to the Sharia Committee fatwa. So that is the second point. So under the new regulation in 2009, Islamic finance institution need to seek advice whenever they have a new product. They need to seek advice from the SAC whether the product is consistent with the Sharia. You know why this is important? It is important because sometimes bank will just design a product. They may not remember, they may not think about the Sharia compliance. They just want to make money. So before they launch the product, they must seek advice from the Sharia Advisory Council of the Central Bank before they can launch the product. So this is one of the importance of the Central Bank Malaysia Act. Next, please. Okay, now despite this, despite the fact that you have many provisions in the Central Bank Malaysia Act, there was still a problem regarding court cases involving Islamic Bank. One of the most important court cases regarding Islamic Bank is Bank Islam Malaysia Berhad, BIMB versus Adnan bin Omar. One of the most important decisions. Sometimes you find part of the decision supporting Islamic banking, and you also find some part not supporting Islamic banking. Because at that time, you find situations which are not so clear. The courts do not give a clear decision regarding the position of Islamic banking products. So in this case, in BIMB and Adnan Omar in 1994 case, one of the most important decisions here was that Islamic banks do not have a religion. They are corporate body because they are a registered company. So they don't have a religion. So they do not fall within jurisdiction of Sharia court. So I think this position is different from in Indonesia, right? In Indonesia, Islamic banks fall within the jurisdiction of the Sharia court. But in Malaysia, Islamic banks do not fall on the jurisdiction of Sharia court. Only Muslims fall on the jurisdiction of Sharia court. Okay, so Islamic banks are not considered as Muslim. This is one of the most important decision here. It looks not so clear, but corporate body, registered companies are not considered as Muslim, although they are Islamic. So they don't fall within the jurisdiction of the Sharia courts in Malaysia. However, now we ask ourselves, where is the jurisdiction of Islamic banks? The federal constitution already provides that banking, subjects like banking, defense, currency, these are one of the items listed in the federal constitution as federal list. When we say federal list are issues which can be decided by the federal constitution and not the state. Sharia issues or things that have to do with Islamic personal law, these will be decided based on under the state list, under the different states in Malaysia. So banking is in the federal list. So that is why Islamic banks do not fall under the jurisdiction of the Sharia courts in Malaysia. So what will the banks do whenever there's any dispute? They have to go to the civil court. Okay, they have to go to the civil court, not the Sharia court. So now there's a problem. At the civil court, most of the judges, they are not experts in usul fiqh. They are not experts in muamalat. So what do? Sometimes Islamic finance cases in the past decided by non-Muslims because they follow whatever is presented by the judge, by the lawyers, by the parties. That's what they follow. So this is a problem. Sometimes decision given by the court is not in favor of the Islamic bank. And sometimes you cannot rationalize. You cannot think why the decision like this. Okay? So because of this, the courts, the judiciary in Malaysia established what is known as the Muamalat bench or the Muamalat court. This court is part of the civil court, but is a special division of the court in charge of Islamic finance cases, only Islamic finance cases. So there was a judge, there was a clerk, they have all the facility established in 2003, but was operational only in 2009. Became operational in 2009, only for Islamic finance cases. But was this sufficient enough? No. This was not sufficient enough. There were still many decisions which were against the Islamic finance industry. Why? Because the judges do not appreciate Islamic banking and muamalat principles. They are not experts in usul fiqh. So how can they give decision? Now, okay, we can say that they refer to SAC. Yes, they can refer to the Sharia Advisory Council of the Central Bank. But what will be the effect of the reference? What will be the effect of the fatwa from the Sharia Advisory Committee, from the Sharia Advisory Council? In another case, Arab Malaysian Finance Berhad and Taman Ihsan Jaya Senior Berhad. This is also about a Sharia compliance issue in the case. One of the points in the case is that it is not compulsory for the court to refer a case to the Sharia Advisory Committee. This is one of the decisions of the judge. The judges felt that they can decide the cases without referring to the Sharia Advisory Council. Because at that time, it is not compulsory to refer to the Sharia Advisory Council. Another important thing is if, for example, if by chance the judge decide to refer to the Sharia Advisory Council for fatwa, the court says that the ruling is not binding on them. That the fatwa outcome, the ruling of the Sharia Advisory Council, the fatwa is not binding on the courts. This is what the judge says in Arab Malaysian finance case. And the last point in this case is that the final determination, even after you got the ruling from the Sharia Advisory Council, final determination depends on the court. The court says that we can decide whatever we like after we got the ruling from the SEC. So with this, it becomes problematic. Many cases were still decided with uncertainty. Islamic banking cases were led to many confusion, and the decision were not so clear and become unpredictable. Okay. So next. So still on the decisions, until 2011, there was still a problem. There were still many decisions which were not so clear. For example, in the case of Tansir Abdul Khalid Ibrahim and Bank Islam Malaysia Berhad, this was involving Bay Bisaman Ajal, BBA. This is the product that became so problematic. The court find in this case that it is difficult to determine Sharia issues in Islamic banking. This appears to be one of the first time that the courts acknowledge that deciding Islamic banking cases is difficult for them. Why did they say that? The judge in this case acknowledged that and says that religion of Islam needs to be interpreted by experts. Religion of Islam or anything that has to do with Sharia, such like Islamic banking products or financing, this requires experts with the knowledge of fiqh and muamalat to decide it. So after this case, it became necessary that some products which were Sharia non-compliant need to stop. So this case was one of the cases that led to the discontinuation, the demise of BBA. So BBA is a kind of product which is very controversial among Sharia experts. some Sharia experts already say that this product is not complying with the Sharia. And there are also some development which led to how to guide the courts. What are the manual for the courts and the arbitrators to follow whenever they find a ruling which needs to be referred to the Sharia Advisory Council? So we have several regulations, several guidelines issued by the court, also issued by the joint judiciary and courts and arbitrators to guide the judges. Next, please. Next slide. So now, after we have the several cases where you have the allegation of Sharia non-compliance, until 2013, when we have the Islamic Financial Services Act, until 2013, this problem did not go away. Why? What do people do whenever they see a product? For example, BBA. The customer will rush to the bank, to the court, and tell the court that this product is not compliant with the Sharia. So when the customer go to the court, what do you think the court will do? The court will say because it is not compliant with the Sharia, that the facility or the financing is not valid. So whenever this is done, the banks will lose. The bank is always the loser in this situation. So when the Islamic Financial Services Act 2013 was passed in Malaysia, there was a provision to help in solving this problem. One of the provisions is Section 281 of the Act. Section 281 of the Act. And what does this provision mean? It provides that no contract, no agreement or arrangement, any product entered into in breach or in contravention of any provision of this Act shall be void solely by reason of such breach or contravention. What the section is saying that if any contract, musharaka or mudaraba or ijara, anyone, if it does not comply with the Sharia, that is not the only reason to say that the contract is invalid. You cannot invalidate a contract because it does not comply with the provision of Islamic Financial Services Act. There are many ways to invalidate a contract, but not to say that the agreement is not compliant with the Sharia rules. So based on this, any customer who goes to court to say that the loan or the financing I got from the bank is not Sharia compliant, that customer will not be able to defend himself. He will not be able to defend himself or run away from liability. Must pay the loan or must pay the facility. Okay, next. So let's look at a few cases. After this section 281 has been passed, what was the decision of the court? Was there any change or not? There were lots of changes. There were lots of changes after the case, the section 281 has been passed. One of the recent cases, 2019, Maybank Islamic Berhad and Golden Base Construction Center Berhad. This is regarding the construction company who took some facility from Maybank. So the decision of the court here is that non-compliance with the Sharia principle does not render an Islamic financing facility or contract illegal or unenforceable. This is because in many cases, including Khalid Ibrahim case, many of the bank customer, they rush to court to say that this agreement does not comply with the Sharia, so it is illegal because they don't want to pay or they want to delay the payment. Okay, so based on this, now with the new provision in the Islamic Financial Services Act, the position already changed. So the fact that the agreement may contain some non-compliance does not make it illegal. It is enforceable. Okay. Another point is the fact that mere allegation, because allegation of Sharia non-compliance, that is not something that you can go to court for. If you go to court to say that this agreement is not compliant with the Sharia, that becomes a mere allegation and cannot be triable in the courts. It is not triable in the courts just because to say that it is not Sharia compliant. Okay. So there are several cases like that. You also have the Bank Kerjasama Rakyat and Koperasi Sebagunan. In this case, 2020 as well. In the last 3 years, you have lots of changes. In the last 3 years, in this case, Bank Kerjasama also mentioned that failure to adhere to Sharia principle does not result in contract being void, invalid, or unenforceable, because the bank make mistake. The banks can make a mistake. If there's a mistake in the documentation, it is not enough to say that that contract is illegal or unenforceable. So this was also decision in the 2024 case this year, Desire Quality, Senator Berhad, and others, including Maybank. Next slide. Next slide, please. Okay, so now for the state of affairs, what we have currently, based on the provision in the Islamic Financial Services Act, we also have what is known as Financial Ombudsman Scheme. This is Muhtasib, Financial Ombudsman Scheme. Under the scheme, which was provided for in Section 133 of the Islamic Financial Services Act, the central bank and the service provider, meaning all the banks, including Islamic banks, they are allowed to establish what is known as OFS. What is OFS? Ombudsman for Financial Services. For the ombudsman, they don't operate like courts. Whenever you have a dispute within the banking and insurance industry, you can report to the ombudsman for negotiation, mediation. Okay, they do negotiation and mediation. They don't do litigation. Okay, so if you go to the ombudsman for financial services and the dispute is not resolved between you and the bank, the customer can go to court after that. Usually, this includes Islamic Bank as well and their customers. And it is only for claims less than or not exceeding 250,000 ringgit. So for claims like this, can try to achieve other method using ombudsman or muhtasib. Okay, this is like negotiation, mediation, but not arbitration. Okay, they don't do arbitration, they do negotiation and mediation. So with this, it becomes more easier for banks and customers to approach the OFS if you have a lower claim, not exceeding 250,000. Regarding arbitration, in Malaysia, we have the Asian International Arbitration Center, AIAC. AIAC has been established for more than 15 years. It has been rebranded. As an arbitration center, the AIAC has I-arbitration rules. What is I-arbitration rules? This is a special rule for Islamic finance disputes only. So arbitration can be done at AIAC between the bank and the customer, and this includes Islamic Bank. So Islamic Bank has several separate rules known as the I-arbitration rule. The I here refers to Islamic. Okay, so the arbitrators will be involved. They are expected to know about Islamic banking and the rules of fiqh and muamalat. So the rule, the latest one, took effect on 1st November 2021. So this is a very important development for Sharia economy. So we have mentioned about ombudsman, we have mentioned about litigation, which is qada, and we have also mentioned about tahkim, which is arbitration. And under the latest rule, under the IFSA, Islamic Financial Services Act, it now becomes mandatory. The courts cannot refuse to refer to the Sharia Advisory Council. It becomes mandatory for them to refer to them, to the Sharia experts for ruling. Okay? And it is not just about referral. Whatever the Sharia Advisory Council says is now binding. Previously, under the Central Bank Malaysia Act 2009 and other rules, before 2013, Sharia Advisory Council rulings are not binding, but now it becomes binding on the bank and also binding on the courts to consider the fatwa. Okay, so we can see that fatwa and the courts work together. Fatwa from Sharia perspective, the courts consider this ruling in the civil court. Okay, in the civil court. Next, please. So what we can conclude based on our discussion so far is that the journey of resolving dispute in Sharia economy, in Islamic finance, industry in Malaysia has been turbulent. Turbulent means that it has become difficult, sometimes smooth, but not so smooth. It has become challenging. It requires, it has achieved what it has today based on continuous legal and procedural reform. Reform by the regulators, that's the banking regulator, the Bank Negara Malaysia, and secondly, the judiciary kept on developing until today. And also important is capacity building. We must build our capacity in ensuring that we are able to explain, we are able to give resolution to dispute through court or through mediation or through negotiation. So capacity building for the judges, capacity building for the Sharia experts to learn more and know how to understand products. And also very important, research is very important. Research on how to solve the problem. The Islamic Financial Services Act is the first in the world. The first in the world to have, Malaysia is the first in the world to have a single legislation on Islamic financial services. And that legislation repealed all previous legislation that is available. So now we have two separate legislation for conventional banking and another one for Islamic financial services. And another very important point is stakeholder engagement. Stakeholder engagement. Who are the stakeholder in Islamic banking? You have the scholars, you have the regulators, you have the banks themselves. So the stakeholders engage together to solve the common problem. And that is why we can say that there is some level of certainty in the nature of the Sharia Islamic finance product and the resolution of dispute when it comes to the Islamic finance industry in Malaysia. With this, I think I have been able to explain more on Islamic banking and the role of the courts, the role of the ombudsman to resolve the dispute, and including arbitration. So I welcome questions from the students and from lecturers on what I have presented. Thank you very much. Assalamu alaikum.
Okay, thank you very much for Dr. Sodiq Umala for your presentation. I think it is very interesting presentation and important presentation. We can look at that in Malaysia also has the large scope in the area of the economic, Islamic economic. You know that between Indonesia and Malaysia has a different term if Indonesia use Sharia economic and in Malaysia use Islamic economic. So I don't know what the reason why it is a difference. And despite the scope of Islamic economic in Malaysia, Dr. Sodiq also explained to us that in Malaysia also have two mechanism, litigation or non-litigation process. But I think it's very interesting when Dr. Sodiq state that uh, in the Sharia court has no competence to settle the problem in the area of the Islamic finance, if I'm not mistaken. So in
Yes, correct,
Indonesia,
correct.
yeah, in Indonesia, I think it's very different because start from
Yeah.
2006 that the dispute in the area of Sharia economic uh, be authoritative competence from the religious court, except
Mm.
the parties make an agreement or arbitration agreement and
Mm.
so forth. But it is the absolute competence from the religious court in Indonesia. Dr. Sodiq also tell to us that in Malaysia has Sharia Advisory Court, Sharia Advisory Council. In Indonesia, maybe we call it as DSN, Dewan Syariah Nasional, or Sharia
Mm.
Nationally Board. Malaysia also has what we call uh, Sharia Sharia advisor. In Indonesia, we have DPS, Dewan Pengawas Syariah, or Sharia Supervisory Board. I think there are some similarity between Indonesia and Malaysia,
Yeah.
but because maybe different in the context of Malaysia belongs to the common law system and Indonesia and the civil law system, so it will bring a difference in the practical. So time is for your participant here for question and answer. So I will give you a time to ask your question, both in Bahasa and also in English. So please feel free, but I will give you for the first time 3 participants to ask the problem. We still have approximately 15 minutes here. So please, if any question, yeah. One is Mbaknya, and then okay, and the left side. If there's no, please three, Mas Alkan, Mbak siapa? I don't know. Please, yeah.
I should start.
No. Just your name and where you come from.
Thank you for the chance. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
I have 2 questions for Dr. Sodiq. The first one is,
Your name, please.
I'm sorry. My name is Armelia Handayani.
Yes.
I'm a student from Magister Ilmu Hukum Universitas Gadjah Mada.
Yep.
The first question is, Dr. Sodiq previously said that the contract that does not fulfill the Islamic principle does not render the contract itself to be null and void. So, what are the consequences, the legal consequences of not fulfilling the Islamic principles themselves? And the second question is, Dr. Sodiq also stated that the before settling the dispute over the arbitration, there should be consensus between the parties. So what are the type of consensus itself? Should it be in the form of contract, or like the Indonesian procedure, we have to give notice first to the other to the counterpart and making the agreement to enter into the arbitration through contract, or what are the steps in Malaysian system? Thank you.
Okay. Yes, please.
Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
My name is Anantia Aliarkan Barik. I'm same like Mbak Armelia. I'm from Magister Ilmu Hukum or Master of Law in Gadjah Mada University. Honestly, I want to ask to Mr. Khotib. I don't know it's can or not. Mr. Khotib, I have a single question. does the existence of several arbitration institutions that have authorization to handle Sharia cases, such as Bani, Basharnas, and LAPS, will give much more good things or bad impact for our alternative dispute resolution system. I believe in one hand that each arbitration institution will compete to each other to get their own client. But I believe too, in other hand, the parties can have many choices to choose Sharia arbitration organ. Or does a middle gate or middle way, does they should merger like BSI atau Indonesian Syariah Bank that before consists BNI, Mandiri, and BRI Syariah Bank before. Thank you.
That's the last question for the first opportunity, please.
Thank you for. Okay, thank you. My name is Muhammad Taran Gibran from Magister of Notary, Gadjah Mada University. My question is to Mr. Sodiq. What is legal reason or ratio decidendi that federal courts do not give jurisdiction to religious courts to examine and decide Islamic economic cases? Do the judges in the federal courts consider the capacity of judges in state judiciary to examine and decide the cases? Thank you.
Okay, thank you for your question. There are two questions for you, Mr. Sodiq. The first question from Amelia Handayani talk about the consequences of the contract that not fulfill the Sharia principle. You know that according to the law, null and void, or in Bahasa we state that batal demi hukum. So what the consequences if the contract is null and void? And also, she also asked concerning the type of arbitration contract. You know that in Indonesia, there are two types of arbitration contract between the dispute and after the dispute. What we call the Pactum de Compromiso, and also the Acta Compromise in Indonesia. So what happened in Malaysia? And the second question from Mas Gibran, you are the vice president, new vice president. Gibran, you know that in Indonesia we have a new president and vice president. The name is Gibran, so it's also from Gibran. So Mas Gibran asks you concerning why or what the regulation why religious court has no competence to solve the problem concerning the area of the Sharia economic. So I think,
Recording in progress.
yeah, please, you can respond the question from our student. Thank you. Okay, please, Mr. Dr. Sodiq. Yes.
Yes. Can you hear me?
Yes. Clear, very clear.
Okay.
From you.
The first question. Okay. The first question regarding Sharia non-compliance. Whenever there is a product which does not comply with Sharia, previously before the new law in 2013, this is one of the reasons why you find the customer, the bank customer, go to court to say that this contract does not comply with the Sharia, so that it is invalid. So the new amendment is to the effect that it is not the customer that should say that the product is not compliant with Sharia. It should be the Sharia Advisory Council. and not the customer. It should be the bank to decide whether their product is comply with the Sharia or not. But you cannot say that just for the one reason that it does not comply with the Sharia, then it's illegal. Because if it is declared to be illegal, it means that the payment will not be made. There will be no payment of the financing. And that is not in line with the maqasid. Because with this, the bank will lose their wealth, the bank will lose their money, while the customer will not pay back their money. And this money is owned by all the shareholders of the bank. So the only reason of Sharia non-compliance will not make the contract to be invalid. So what the court can do is refer to Sharia Advisory Council and not the customer to say that it is not compliance, is invalid and unenforceable. It will still be enforceable. Even if it is non-compliant, it will still be enforceable. The next time, then the bank will not consider that, because the Sharia committee of the bank, Sharia Advisory Council of the central bank, they will have to stop the kind of contract from being created again. For example, now BBA no longer a product in Malaysia, because previously it was considered to be Sharia non-compliant. Now the most product used to replace BBA is Tawaruk. So I don't know if this is already discussed in Islamic banking. Tawaruk is a new product which is now not having the same problem. But another thing is, can we allow customers to always raise this issue all the time? For example, can you go to the restaurant, buy the food, and after you buy the food, you say the food is not sweet? I think you understand the idea. You get the food, you say the food is not sweet, and you will not pay.
Yeah.
So I think this is the problem. So this is what many customers do, and now the law was changed in order to make sure that the customers will not risk the fact that it's not compliant with the Sharia anymore. Okay, so that is just like a remedy. Section 281 of the Islamic Financial Services Act is to protect the banks and protect Islamic finance industry in general. I hope this answers the question, right? The second one from the sister is regarding how does arbitration occur regarding Islamic banking. All kind of EDR, negotiation, mediation, and arbitration should be based on if the parties wants to do the arbitration. And that is why in every contract, there will be dispute resolution clause. Dispute resolution clause. This is just one of the provision regarding how do we resolve the dispute if we have a dispute regarding this contract. So one of the ways to resolve dispute is arbitration. Okay. So if you have the clause in the contract, it means that both parties already agree that if there's a dispute, we go to arbitration. For example, you can say, where is the forum, where to do the arbitration? It could be in Jakarta. Even if the parties are from Malaysia or Singapore or Nigeria, for example. They can choose to have Jakarta as the place or seat of arbitration. So that is before the dispute, right? But what if the contract, the Islamic finance contract already drafted, but the lawyer or whoever drafted the contract did not provide for dispute resolution clause? Then after the dispute occur, the parties can enter into arbitration agreement. After the dispute, they can enter into arbitration agreement and agree to arbitrate. But if they don't want to enter into the agreement, then you have to go to court. So these are the options. However, how you commence arbitration, I think it's the same thing almost everywhere, generally same. You have to issue a notice of arbitration to the other party that there is a dispute regarding this contract, and this is a notice that we want to commence arbitration on this date and date. They appoint an arbitrator and proceed. But what is different between this is because it is Islamic finance contract, the arbitration, the law, applicable law will be Islamic law. Okay, the applicable law, Islamic law, and that solves the problem. So parties can always agree. If the parties do not agree, you cannot resolve the dispute. So, and if parties do not agree, you can only go to court. So that is the reason why. That's why the Quran says, "In yurida islaha." If the parties want to resolve, if parties don't want to resolve, cannot arbitrate, cannot do mediation. So that is the importance of ADR in Islam. Okay. The next one, yeah, this is quite differential. I will explain a little bit on the jurisdiction of the scope of application of the Constitution. In most of the common law countries, there are some subject matter. For example, defense of the country. Defense of the country is on the federal list. Federal list means that only the federal government can decide on these issues. Banking also under the federal list. So there is no separation between Islamic banking and conventional banking at the moment in most of the common law countries. So that is why the courts in Malaysia says that the Sharia court do not have jurisdiction when it comes to Islamic banking matters, because Islamic banking is still considered as banking, which is under the federal list. Federal list in Malaysia, it refers to topics which are under the scope of the federal government. So this includes external affairs, immigration. So federal government different from state government. So Islamic banking is under federal government. So now regarding the courts, as long as the subject matter is under the federal list, only the civil court can have jurisdiction. Only the civil court can have jurisdiction regarding banking. But regarding other Sharia matters, for example, family law, custody of the child, divorce, these other matters, Islamic personal law, these are under the state list. State list meaning that only the Sharia court at the state level. At the federal level, there is no separate Sharia court. I think you get the point. At the federal level, no separate Sharia court. So whenever the civil court has a Sharia issue to decide, whether in banking or any other topic under the federal list, they will refer to the experts. This is the rule of the fatwa. So the fatwa given by the experts, for example, in the banking, can be applicable by the civil court. And now you can see in the new regulation, Islamic Financial Services Act 2013, it becomes binding on the court consider the opinion of the Sharia Advisory Council of the Central Bank. Same thing at the level of halal industry also. Halal industry, they have is a state matter. It's different from banking, but the expert can give opinion to the civil court if the cases go to the civil court. So I hope this is one of the differences between Indonesia and Malaysia, but this is a constitutional matter in the Malaysian constitution, and this until it's amended, this is the position of the law. Banking, including Islamic bank, is a federal matter. For example, another thing, there is no Islamic banking enactment for different states, only one throughout Malaysia. So because it's only one throughout Malaysia, then the states do not have jurisdiction when it comes to Islamic finance cases. So until there's a change of the law, this is the position. Okay.
Okay, thank you very much for Dr. Sodiq for your answers. And I believe that all of you still have any question,
More
but
questions.
yeah,
Yeah.
because the time, I think that for today discussion is enough. We still have one question from Mas Anantia. You asked me concerning there are several non-litigation institutions in Indonesia, namely Badan Arbitrase Nasional Indonesia, Badan Arbitrase Syariah Nasional, LAPS, Otoritas Jasa Keuangan, right? So I believe that the several institution is still okay in Indonesia because you know that if we talk about the non-litigation process, it's mean give opportunity to the parties to make an agreement, make a clausula in the contract because the nature of the business dispute are open system. It's belong to the freedom of contract according to the Indonesian law. So it is okay, at least in the theoretical level. You know that in Bani itself also has the Sharia compartment in Bani. But because in Indonesia have Badan Arbitrase Syariah Nasional who has the specification in the area of the muamalat, in the area of the Sharia economic, Bani is very well get the case from the customer and also the financial institution. But Basharnas basically have the authority only and only if the parties make a arbitration clause in the agreement. So, like I said before, that the existence of LAPS, LAPS stands for Lembaga Alternatif Pilihan Sengketa, Sharia Dispute Resolution, ya, Alternatif Indonesia, established by OJK. OJK suggests that all of the conflict between the parties, yeah, for the first time, please settle in the LAPS OJK. So as a consequences that in Indonesian practice, if the banking or the other financial institution not state in their contract, so OJK will give suggestion, just a suggestion. So in the theoretical level, it's not the problem, but in the practical, sometime like the explanation from the practitioner that it minimize the authority from the Sharia arbitration institution in Indonesia. So I don't understand what the second question concerning merger. So merger between, yep. Okay, I think it is not necessary to be the one arbitration institution. So it is feel free for the customer to choose the institution. Litigation not need the apa the choice the forum from the customer. But if the customer want to settle the problem in the non-litigation, just please several institution, it's okay, labs, Basharnas, or maybe Bani, or maybe the other arbitration institution in other country maybe. Yeah. Okay, I think today is enough, especially for the Dr. Sodiq. Thank you very much for your time, for your information, yeah, sharing your information to us. I think that the student get much benefit from this meeting. So we will continue to discuss, I think, in the next week in the subject of the banking law, especially for you, from you. You will meet Pak Mohaimin and also with me in the 4 till 6 meeting in after Pak Mohaimin. Okay. So thank you once again. Thank you very much for Dr. Sotik and also for all of the participants. Yes, I think it is very important. Please be prepared to with the law regulation and also the reference, especially in the Indonesian context, and also you also can find how the other country regulate concerning the Sharia economic. Okay, thank you very much. Assalamualaikum warahmatullahi wabarakatuh, and good afternoon. See you in the next time. Thank you. Thank you, Mr. Sodiq.
Okay,
Yeah.
Assalamualaikum.